it.
Welcome to Legalized Negligence, where we discuss Florida Statute 768.21, subsection 8. And Travis and I are just both of us are busy doing our own research, and Travis had been tied up with his civil court case. And we haven't put out a podcast in a couple of months, so we wanted to do a short one to kind of catch everyone up on where we're at. Travis, would you like to kind of just give us a brief overview of where your case stands? Our last podcast was about what you had filed and where things stood a couple of months ago.
Yeah, currently where I'm at is I just had my case management meeting, which sets the first date for a hearing, which will be the first of many motions to dismiss. I think I have a good argument that will overcome them and thus allow me to move forward on each and every one of them, because they're all bringing motions to dismiss based on medical malpractice, which I can't claim medical malpractice. So
right, you're trying to show other issues that are that never get into court because we can't get an attorney to take the case, issues that the courts need to hear.
Correct.
You mentioned fraudulent concealment. I would venture a guess and say that probably every case that falls under subsection 8, we could find some kind of concealment in it. As much as you've gone through your mom's medical record and I've gone through my mom's medical record, we both know that not everything we requested was given to us. And as you showed through the HIPAA laws, they're required to give you a lot more than what they've given to us. So we're claiming concealment of that information, which has a 7-year statute of repose, which means that instead of being limited to 2 years or 4 years, you have 7 years to pursue that. And even though it's not an issue of medical malpractice, it is an issue of getting that case before the court to see how the hospital and the doctors are concealing information from us.
Right. That's really the crux of what started it, is the concealment. And because they concealed stuff, it kept me digging. And because I kept digging, I kept finding. And more people got dragged into it because the hospital just didn't provide, as the custodian of the records.
Yeah, I'll have to share a funny little story with you. This is the week that 4 years ago everything started happening with my mom. Today is the 4th. On April 29th, 2020, she was admitted to the hospital. 4 days later is when she fell because a nurse left her bed alarm disabled. And when she tried to get out of bed, nobody was alerted to that fact, and she fell and broke 5 ribs and bled internally. So it's been 4 years since I requested medical records. Yesterday, I called the hospital and I told them, I said, I have looked through your online portal to try to request medical records, and I have some questions. I said, number one is, it only gives me like 4 categories of people who can request the records. One is the patient, another is the guardian, another is an attorney, and another would be, I forget what the 4th one is. But anyhow, I said, I don't fit into any of those 4 categories. And they said, well, who are you? What is your relationship? I said, I'm the personal representative of the estate. And, oh, well, let me go check with my supervisor. Then they came back and they said, oh, well, you can click power of attorney. And I said, well, it's not the same thing as power of attorney, but if that's the only option. And I said, now, also, I noticed that you only allow me through your portal to request certain documents, certain records. I said, but HIPAA law allows me to have much more than that. I said, there's the designated record set that you don't say anything about. There's the audit trail that you don't say anything about. And you could tell this woman was getting more and more nervous the whole time. And so finally she
Yeah.
says, let me go talk to my supervisor. And she came back and she said, we'll send you a link and you can fill out the form that's contained within that link. And so I'm thinking, now I flagged myself for them, and that when I fill that form out, it's going to be a struggle. But that's what I wanted to accomplish. I wanted them to start, giving me problems, because that's what I'm going to be able to show a judge. This is what happens when you try to request the documents that HIPAA allows you to have. And so that's the whole theory behind, filing something under fraudulent concealment.
Right. Yeah. The don't use their forms. Create your own
Oh yeah, I
form,
will.
send it in, because
Yeah.
their forms are limited to their benefit.
Mm-hmm.
It'll leave off the designated record set. It'll leave off the audit trails. It'll leave off communications. All they're going to give you is the medical record, and you're entitled to so much more. Now they can argue, a burdensome, to produce all that. But my argument will be, with the audit trail, for example, they're required by HIPAA to conduct their own audits of the audit trail.
Right.
They got to look at it themselves. So how can it be burdensome to have them do what they're supposed to do anyway?
Right. Yeah, they're supposed to have already done it. We're just basically asking them for a copy of what they've already done.
Yeah.
And it's like my brother told me one time, I think I've shared this with you. He said, you don't have to be the best lawyer in the courtroom. You just have to be a fly in the ointment, and the more headache you can cause them. And I'm sure somebody will eventually look at this and go, this case is 4 years old. Why are they still asking for things? And of course that makes them a little nervous, and
Yeah. And put government agencies to work for you. File your complaints, and then if they don't give you the results, because they didn't find anything, then file a FOIA and get it that way. I filed on CMS. I filed on ACA, DOH. You can get a lot of information through a FOIA request.
yeah, and like you showed me the other day, CMS provided you things that you couldn't get on your own, that they wouldn't give to you.
Yeah, and actually one's going to be a really good part with the post-surgical cabbage pre-extubation protocol, whatever, SBT, SAT. It says right down in the bottom left-hand corner, do not scan into the medical chart. Direct violation of HIPAA. And right above that says patient sticker, so it's identifying the patient. And then to the right, you record the stats for performing the SBT and the SAT. So right there, that's a medical record.
Yeah,
and I don't have it in the medical chart, and the investigator didn't see it in the medical chart. So right there, exhibit.
Like you pointed out to me the other day, if they created a document and left a space there that says place patient sticker here, that means it was intended to be a part of the medical record, and then right below that, they leave an instruction for their staff to don't scan this into the medical record. Yeah, I don't think that these hospitals and doctors and nurses were prepared for you and me to come along and start questioning a lot of this, but that's how things get done. You start going down rabbit holes, and you start finding things that nobody else has ever brought to their attention, and that's how you make change. This is a really good segue when we're talking about doing all of these things, all this time later. I want to talk a minute about the time in between when the legislature goes into session, which was back in January, then 2 months later when they go out of session, then what happens from then until the delegation meetings start in the fall, and then from the time the delegation meetings start until the legislature goes back into session in January. And now is our perfect time to build our arguments, gather our information, get our data and our stats together, and form cogent arguments to bring to the attention of our legislators, so that when the delegation meetings start and you're limited to 1, 2, or 3 minutes to speak, you've already had correspondence with them. You've sent them all of this research. They're very familiar with our arguments. They're very familiar with what the problem and the remedy that we're offering to them, which is what the Constitution means when it says we can petition for a redress of our grievance. And that word redress means a remedy to our grievance. We petition them and we tell them, this is what we want you to do. And then we back it up with all of the data that we have gathered over the past year and a half, and we share that with them. Because really, you're getting in a new crop of legislators every 2 years, at least every 2 years. And a lot of them don't know what happened back in 1990. They don't know what happened in 1988 when the task force was formed. They don't know what happened back in the mid 70s when all of this stuff about the medical malpractice crisis started coming, to the forefront. So these are new people, and they're not familiar with the subject. So now is our time, between now and when the delegation meetings begin in September or October. Now is our time to bring it to their attention. It's our responsibility to do that. If we're going to make a change, if we're going to get subsection 8 repealed, now is the time to do the work. And when we go to the delegation meeting, we don't have to sit there and tell our story about how our mom died or how our husband died or how whoever died. We just can say, we've spoken about this over the past year. We've sent you the documentation. We've sent you reams of paperwork to show all of the stats, all of the court cases, all of this. I'm here to remind you about that. And then our next opportunity to speak to them is when the legislature actually goes into session. And, that's when you're going to get to speak, when they're actually going to be taking a vote on it, in the various committees. So the delegation meetings and the committee meetings after the legislature is in session is not the time to make your case. Now is the time to make your case.
Yeah, because now you can get 15-minute meetings with your representative.
Exactly. And I think that that's where people have fallen down in the past, is they haven't put it together that now is the time to write to them, talk to them, have phone calls with them, set up meetings with them. In fact, I know that it didn't have anything to do with subsection 8, but you sat down and talked with your local representative this past week. She's out of the legislative session. You scheduled a meeting with her. You went in and sat down and talked, and you addressed the issue that you had. That's what people have to do.
Yeah, I went in prepared. I had all my exhibits that I'm basically going to be using in my court case. And I just went page by page showing, and you can almost see the disbelief in their face. And granted, she kind of knew some of this was going on with like ACA and DOH, but she didn't see it. Yeah. She didn't have tangible proof in front of her. So I think we do them a service by showing them the records, rather than just them hearing it from us.
Yeah, and then you hear the advocates who would like to see the law repealed. You hear them say, "But they limited me to 2 minutes. I couldn't speak to it." Well, you've had months. Yeah. You've had months to do this legwork. That 2 minutes that you get at the time the delegations are gathering, that's just to remind them. That's just to say, I left you a handout. I mailed you this court case. I did whatever.
Yeah, if you want more than 2 minutes, now's the time to do it.
Yeah.
If you don't do it now, don't gripe about 2 minutes or 1 minute.
Yeah, that 2 minutes or 1 minute is just for you to reappear and say, "Remember me? We've been talking all year, and I'm here to remind you that this is what I want you to do."
And the thing is, my representative is literally within a mile and a half of my house, probably a mile. And I didn't know that until I actually went and researched,
Mhm.
who my representative was. It's like just right around the corner. Couldn't believe it. Very convenient.
Yeah, and they would rather talk to you now when they're not. I mean, when they go into session, they're so busy. They don't have time to sit down with you for 30 minutes or an hour and go over all these little details. Now's the time to prepare for that, you know, and get them up to speed with it all. And you and I will be happy to share the work that we're doing with them. We do it in podcasts, but if somebody wants to write to us, we'll share the research that we've done so that each individual can be prepared and know what they want to talk about. And speaking of that, I put a post in our Facebook group. I guess it was yesterday morning, day before, asking if anybody would like to join us in a podcast this coming week where we're going to talk about, subsection 8, some of the avenues that we're taking to have it repealed. And we've got several people that have said they wanted to join, and hopefully they'll, ask questions and take notes and start to get involved in the movement. We really need to have a unified front by the time the fall rolls around so that we're all saying the same things and we're all on the same page instead of each person going in there and it's very disjointed, and they can't put it together that this is all the same. This is the same group of people making the same arguments, you know and we need to pay attention to what they're saying. And I will say that I have reached out to Senator Yarborough and Representative Joel Rudman to ask them if they wanted to do a podcast with you and I to talk about, what happened in this past legislative session and why did the bill in the House die and the bill in the Senate die. And Senator Yarborough hasn't even responded, which is very disappointing, given that he had specifically said, I want people to contact me. He was asking for new ways to thread the needle. We took him up on that, and we've tried to correspond with him about that, and he has just been absent, completely
Sent
absent.
him a solution. Sent him a solution and didn't hear a thing about it.
Yeah, he has not responded at all. And Representative Rudman, it took him a couple of weeks to respond, or it took him a couple of weeks for his aide to respond. And all the aide said was, "This is not a good time." I thought, well, when is a good time? You know, Maybe if you put your guitar down for a few minutes and take up an issue that the people are concerned about, um, I think it'd be a good time. That's what the people want. That's what you don't just work 2 months out of the year. You're supposed to be available to people all year round when you're a representative or a senator. So, but I plan on Monday. I'm going to send out several more invitations to all of the lawmakers who were involved in this, like in the Senate committee meeting, Judiciary Committee meeting. Um, there were quite a few of them in there. Senator Lauren Book was one. Uh, there were several that spoke about it, and same in the House. Representative Lopez, Representative Beltran, Representative Benner. There's quite a few of them, and I'm going to send invitations to every one of them and ask them if they'll do a podcast with us. It's funny that the one person who did respond to a request was a lobbyist who wants to keep subsection 8 in place. And
Our opposition. Yeah.
he was more forthcoming. His name's Mark Delegal. A lot of people don't like him, but to be honest, Mark has been very open and honest with us.
Yeah.
And he spoke to us for roughly an hour the other day, and he seems to be very willing to read whatever we have and to work on. I don't want to call it a compromise, but even though I guess it is, but really it's more look for a solution that works for everybody. You know, he really seems to be willing to do that. And it just struck me as funny that the opposition is the only one who was willing to talk to us. And so far, those who in the legislature who say they support the repeal of subsection 8 have been very distant.
Yeah,
Hopefully that will change.
fear not, we're not going the caps route.
Yeah.
Yeah, not going that route.
Yeah. Some of the other things that we've been doing is I'm in the process of getting a website built for legalized negligence. I have set up accounts at some more social media platforms that I have not launched publicly yet, but I will when the time is right, so that when the delegation meetings begin, we'll have a more instantaneous way of getting information out to people through one of them is going to be, I think they call it X now. It used to be Twitter, but I think they call it X. I've set up a legalized negligence account there. I've got one on Instagram, but I will actually launch those later on. So hopefully people will follow us on there and can see the current information that we have available to share with our legislators. And I am also currently building a wiki page to deal with with subsection 8, so that people who don't know about it, and I was kind of floored yesterday when some people had no idea what subsection 8 was, but they're part of some of the Facebook groups that deal with this issue. And I thought, well, how can you not know what it is? That's all we talk about. That's all our videos, our podcasts are about. But I'm currently building a wiki page so that if somebody wants to look it up, they can learn a little bit about it. And of course, with Wikipedia, to me, it's just a jumping off spot for more research. It's good for an overview of a topic, but I wouldn't trust it like I would, like an Encyclopedia Britannica. That's it's not the same thing in my view, but it is a good place to share general information. Do you have anything specific you want to talk about?
I would like to put out there that people could dabble into artificial intelligence from their home.
Yeah, why don't you tell us a little bit about that? I know you've been sharing some of that with me, and it is fascinating. It really is. Why don't you talk to us on our level, Travis? Okay, keep it on the layman's level.
Okay, since I can't get an attorney, the best thing I've been able to do is create my own artificial intelligence workstation, where I can put into it the medical records and such, and make that searchable as best as possible, and then query information from that into what's called a large language module, LLM, which is what ChatGPT, Copilot, Microsoft now has. But on some of these, you can download them onto your own workstation. Microsoft has Pi 3. Elon Musk, he hasn't put his out, but he's got his X.ai coming out, and such. But it's amazing the information. You have a question, you can ask it, and it will give you cases. And then you can go back and Google those cases, download the PDFs, read them. It's like having an attorney there. You need to validate everything. It is not an attorney. It is trying to find things based on little crumbs that you give it. So it's not 100%, but it does a really good job of finding relevant case material if you keep digging. And it's been useful. It really has.
For those of us who are not IT guys like you, give us kind of a basic thumbnail sketch of how this works. I'll share with you what you've taught me. It's like you take these bundles of data It can be legal data, it can be medical data, it can be any kind of data that you have, and you just feed it into your computer. You download all of this knowledge into your computer. And so you're basically, it's like when a human goes to school and he's downloading knowledge into his head. He's reading books, he's listening to lectures, he's doing all that. So basically, you're feeding all of this information into your computer so that then you can go back and ask it questions, and it searches all of that data that you have fed into that to come up with answers. Is that a basic?
That's pretty close, because let me create two scenarios. One is you run the AI in the cloud through like Copilot and whatever. It's not running on your machine. Okay. Or you can download the LLM, the large language module, which is created by like Microsoft and whoever else, and download that on your own computer and run it locally. It runs a lot faster when you do it in the cloud, unless you got a very good graphics card. But the large language module is a database of billions and billions of data points. Okay, you mentioned Encyclopedia Britannica, whatever. Imagine that being there, plus all the history of law, all of medicine, stuff like that. They just threw data at it, and then they run it through this program, and it converts all the words into numbers. Because computers deal with numbers, ones and zeros. Okay, and then it takes our spoken language and interprets that and finds the relevant numbers associated to what we're asking. And then it spits it out in a response. Now, to take that further, we can do what's called a RAG, R-A-G, where that's the repository that we're augmenting with our own personal data. Okay, so then I have this database, this RAG that I've created. I put my question to it. It pulls out information from it and then takes that and gives it to the large language module, the AI. And so now it's more fine-tuned based on my specific data. And it spits out more stuff. And it's amazing. I am just thrilled at what it can do. They've gotten it to where you can draw a diagram, upload a diagram, and it will explain or create programs based on the logic flow of stuff. So again, for pro se people, it's a tool to really be utilized. But again, validate everything. Just because it gives you a case citation doesn't mean it's gospel. You need to Google that and verify that it's correct, because there's a thing called hallucinations where you're limited to a conversation of this many characters. What you ask it takes up some of that space, and then what it spits out takes up other space. And if you didn't fill it all in, you can go and ask it more questions, and it will eventually fill that up. And as you get closer to that limit, it starts throwing gibberish out. Okay, so then you got to start a new conversation. Okay, but it's totally forgotten everything you've told it before. So you kind of pick and choose. You get better refinement to your questions as you learn how to use it. Then you take that and you start a new conversation, and it's very concise and accurate now that you're starting that conversation with, because you refined it in previous ones. But again, I can give it a medical chart and tell it, give me an Excel table, based on this information. Boom, there it is. Copy, paste into Excel. And now I can sort that. So it's just amazing.
So people who watch our podcast routinely know that neither one of us are attorneys. So on occasion, you'll call me and you'll ask me a question, and I'll share my knowledge base with you, or I'll call you and ask you a question. You'll share your knowledge. But we both know that this is not gospel. This is just what you and I as regular guys know. And then we'll go and research it further. And that's kind of what you're saying about this is, take the information that it gave you, because it searched a tremendous amount of data to come to that answer, but then use that answer to do further research.
Correct.
Okay.
Correct. Yeah. For example, I might say, give me 5 cases where fraudulent concealment was used in the state of Florida. Limit your answers to Supreme Court and Florida Supreme Court opinions. And boom, it'll give me 5 cases if 5 exist. You know, I'm like, okay, so now I got 5. I got somewhere to go read. You know, or you can just say summarize this case, and it'll give you a little paragraph like, okay, that one's worth more investigation. Now Google it, verify it, see if it really applies. But I wouldn't have had that case if not for the AI for asking it, and it usually spits it out pretty quick if you got a good GPU. You know,
Yeah.
but
I don't know if many laymen know this, but there is it's almost like its own internet that attorneys use. It's called Westlaw. It's its own network of lawyers and cases and anything to do with law, and it's extremely expensive to use it. You have to have a terminal in your home or in your office, and it costs a lot of money to use it. Well, if you ask an attorney a question, he can just turn around to his computer, hop into Westlaw, type it up, and he can pull this. We can't do that because the average person can't afford to have Westlaw. But you're doing the same thing. Is you're able to draw from a knowledge base dealing with the subject at hand and type in questions and get answers because you can't get into the database that the attorneys use.
right now I could drive downtown, go to a library that has a Westlaw terminal, but as you and Paul have told me, and I found to be true, books really have a lot better data than what you find online. But because of my occupation, I'm self-employed with no employees, I got to sit in this chair during the day, and then when my work day is done, the library is closed. So I'm really dependent upon what I can do with AI and surfing the internet.
So give me just one simple example of how that LLM, large language module, can help somebody who is dealing with subsection 8. I mean,
Well,
how can it help our cause in getting subsection 8 repealed?
put me on the spot. It depends. Are you looking for other torts that might be related to your
Okay, well,
circumstances?
okay, you've heard me talk about the 2000, no, that was Mizrahi. I can't remember the year for National Deaf Academy v. Towns. You've heard me talk about that case before. And basically what that case was about is the Florida Supreme Court gave a very clear definition of what is medical malpractice and what is not medical malpractice. So if you could feed that case into your large language module, you could ask it to summarize that case for you, since since we are not attorneys, and I think the case was 7 or 8 pages long, their opinion, and there's a lot of legalese in there that's difficult to understand. But you could feed that into the LLM, ask it to summarize it, and it would give you back a readable, understandable summary of what the case is about.
Yes. Yeah. It's like I could ask it, what is Florida Supreme Court definition of medical malpractice and what is not medical malpractice according to Towns v. Do you remember the rest of it?
National Deaf Academy versus Towns.
TOWNS?
TOWNES.
Yes, that's why. Yeah. Right. It takes a minute. Um, I don't have a GPU. I have to run it on the CPU.
Yeah.
So it'll take a little bit.
Yeah,
but yeah, it's a great tool. It really
I
is.
think you doing this is like really cool. I really like that you've done that.
Well, it'd be really interesting if this was the first case in Florida that a pro se wins using artificial intelligence.
Yeah. Well, I know, read a lot of legal websites, and more people are discussing AI becoming part of the legal community, and what is it going to do? And some people say, well, it's going to solve contract issues in seconds where those used to be solved over months, a contract dispute. There's going to be certain things that it's going to be helpful with. Some people argue that it's going to get rid of a lot of jobs because now they're not needed. But I contend that no matter what AI can give us in the future, you always have to put a set of eyes on it,
Yeah.
a set of human eyes.
Well, what's happening now is you create skills and agents to interface with the AI. I'll give you an example. You know how we can talk to Alexa and have it do certain things like call people, send a text message, turn lights on, stuff like that. So just look up a voice communication capability to where it reads out the response and have the response talk to Alexa and then turn a light on kind of thing. You can have it reach out, and that's what they're working on now with agents is interacting with the physical world from the digital world. Okay, I'm getting my response now. An important case that should be considered in the context you provided, National Deaf Academy Incorporated et al. Versus Towns and Towns, Florida Supreme Court case, SC 14-1917, filed October 15, 2015. I will summarize below and follow with an excerpt from this opinion. The Florida Supreme Court said, appellants contend that the trial court erred in dismissing their claims as a matter of law because it did not apply the definition of medical malpractice set forth in section 766.102 subsection 1 to determine if there was sufficient evidence by review by the jury or for review by the jury, and instead used an improper standard. Section 766.102 is entitled definitions. It states that medical negligence or negligence means a departure from accepted standards of medical practice shall be defined with particularity in any expert report required under this chapter. The definition for a healthcare provider as used herein in the definition set forth in 766.102 subsection 1 are not applicable to claims brought against healthcare providers within 1 year after such a departure from accepted standards of medical malpractice or outside of an appropriate relationship between patient and the physician. Then it gives another statute there. In this case, Towns and Towns, PC, the firm that represented National Deaf Academy, the defendant, argued in its motion to dismiss the definition section is not applicable because it does not define medical negligence. The court then noted Towns' argument misapprehends Florida statute 768.0405 and relies on an outdated version of the statute, which provided that the definition set forth at statute 766.102 subsection 1 are also applicable to claims brought against healthcare providers within 1 year after such departure from accepted standards in medical malpractice or outside, in medical practice or outside appropriate professional relationship between patient and physician. Gives another statute. In Florida's legislature's most recent revision, the language was changed so that it now reads, the definition set forth in the statute are not applicable to claims brought against a healthcare provider within 1 year after such departure from accepted standards in medical practice or outside an appropriate relationship between patient and physician. Gives a statute. Therefore, the issue of whether section 766.02 is retroactively applied under its savings statute at statute 90.148 subsection 6 to any claim filed more than 1 year after July 1st, 1992 remains an open question. In this case, Townsend and Townsend motion to dismiss was granted because there was not sufficient facts in the record for a jury, and it did not appear that National Deaf Academy had brought claims outside of an appropriate professional relationship between patient and physician. The Supreme Court said The issue is whether, under the statute, you must have an actual agency or employment contract with the school in order to be considered a healthcare provider. The court found that there was no evidence of such agreement. Here's what section 768.40 says. Definitions for purpose of this part, as used in state statute 766.767 and 768, medical negligence or negligence, a departure from accepted standards or medical practice shall be defined with particularity in any expert report required under state statute 456.063. Subsection B, healthcare provider means a person who is licensed pursuant to chapter 458, part 1, subsection C, subsection A, patient and physician means an individual acting within the scope of his or her practice as established by law, the healthcare facility, which shall be defined with particularity in any expert report required under this act. Florida Supreme Court says, wow, this keeps going.
Yeah.
They're obviously billing by the hour.
Yeah. What I was looking for is, and it took me, I had to read that case several times to finally get to it, because I'm not an attorney and it takes me a while to figure it out. But basically it came down to the difference between medical malpractice and ordinary negligence is what the medical licensee doing? Is it diagnosing or treating the patient's condition? And if it's not, then it's ordinary negligence. That's what it came down to. So let's say, I'll pick something weird. Let's say that they were taking a patient's temperature and they shoved the thermometer too far down their throat and they injured the patient. That would be considered under medical malpractice, because they were ascertaining the patient's health condition or treating it at the same time. But if the nurse handed the patient a cup of hot tea and spilled it on them, is that medical malpractice or is that ordinary negligence? Well, giving the patient a cup of tea is not ascertaining the patient's condition or treating it, unless the tea was prescribed to treat the patient's condition.
The part of daily care in terms of like the food service, it would probably fall under that.
Well, it goes further than that, but I mean, we could have that discussion another time. It has to be, it's like one of the justices argued that not everything that happens in a hospital can be considered medical malpractice, and just because they bring you I don't know, they bring you a towel or a washcloth or something for your daily needs, you can't say that that's treating it. It has to be very specific to whatever the illness is or the injury is, Anyway, I think that that's a cool thing, that LLM. I would like to at some point be able to download all that stuff on my computer and be able to do the same thing.
Increase your storage capacity. I have 500 gigs of data that I've downloaded for this.
Yeah, I'm waiting until I get fiber optic cable in my neighborhood, which is supposed to happen sometime this summer. And then I'll do it, because right now I'm charged per gig, and it's I pay $10 per gig of data. So I don't have that kind of money right now. But once we get fiber in my neighborhood, then I can download it. And it's really, you just buy a 2 terabyte external hard drive and download all of that stuff onto that hard drive.
Well, you need fast storage. I would say a solid state drive, just because some of these LLMs, it's like I'm using a 74 gig large language module and I'm pushing that up into my RAM. That's a lot to move around every time you do something,
Well, I didn't mean to take you down a rabbit hole with that, Travis. I'm sorry.
Oh, that's all right.
But I do think it's cool that you're doing that, and we can utilize it to help us fight this battle because it will help us pull up information a lot quicker and provide it. You know, if let's say Mark Delegal asks us a question about something that we don't know yet, I think we could use that to help us get information. So
I kind of see, dare I say, a business model where you have a focused, attuned, as they say, large language module just for law and medical,
mhm.
and make it available for those of us to do something with.
Yeah, you should.
I would like to create that.
I don't know if you've already inputted this information, this data yet, but you might want to consider anything to do with medical malpractice insurance. I don't know how you would find where would get a bundle of data on that, but that would help us figure out, because their story. Their story is doctors are leaving the state because their premiums are too high. You and I have found that that's not true. Using the Department of Health's own statistics, we have found that that's not true. But it would be nice if somebody throws a question at us to be able to find an answer like that real quick without having to spend days or weeks, researching it.
Right. Yep.
So, well, does that kind of catch us up from where we were 2 months ago?
It does.
We've got,
It does a good quick calendar of what
yeah,
we've done, accomplished,
yeah,
and been doing.
we haven't gone away. We've just been working on things. I've read several books since our last podcast on malpractice and this supposed crisis. And like I said, we had a meeting with Mark Delegal last week. He's agreed to meet with us, a couple of 3 more times before the delegation meetings start in the fall, and hopefully we can have come to a reasonable agreement on how to approach it so that we can get legislatures to say, hey, these guys have already done the work, talking about you and me and Mark and whoever else wants to get involved. They've already come to an agreement that seems to satisfy everyone.
Yeah. Yeah, we need to educate the legislatures before the legislature starts.
That's key. That is
Yeah.
absolute key, is now's the time to do that so that when they go in there, they're prepared. And a lot of these legislators run for office because they have a particular issue that's interesting to them or that's important to them, and they have no idea about this law and that we've been out here fighting against it. And all of a
Yeah.
sudden, they're now newly elected and they're at a delegation meeting and they're hearing somebody talk about subsection 8. They're going, what is that all about? Well, now's the time to bring it to their attention.
And I would think that if you create the contact now and you have a good rapport with them, it's going to be much easier to get that meeting time at the Capitol, because they'll recognize your name, they'll support your subject matter, they'll be happy to meet with you.
And you just said something very important: have a good rapport with them. Don't be known to them as, oh, that's the guy that yells and screams and shakes his fist in my face. Be known as the guy who sits down and has a reasonable conversation, and he's got research and data to support his points of view. Be that guy. All right. Well, thank you for joining me, Travis. I know we both have stuff we got to get done this afternoon. I'm going to stop the recording and ask you to hold on for a minute, and then we can end. Thank you, everybody, for joining us. Look at our videos on YouTube. Join us on Facebook.
Like,
subscribe, do all of that stuff. Invite your friends to do the same. I haven't done it in the past, but I'm really going to start pushing that because the more people that can share our work, the more people that we will have to speak to the legislators this coming year. So please work with us on this. We would appreciate it. Thank you much. Bye.